further ado, ladies and gentlemen, I'd like you to put your hands together for Mr. Farhan Farani from Farani Javid Taylor Solicitors.
Thank you very much. First of all, I would like to thank His Excellency Wajid Shamsul Hassan for providing this opportunity to us to host this event. I would also like to thank Mr. Farooq Naek, our Honorable Chief Guest for the evening tonight, for attending this event and making it a special occasion. I would also like to thank members of my legal profession, my legal fraternity who are present here, and the distinguished guests. Ladies and gentlemen, the purpose of this evening is to provide an opportunity to those individuals who are geographically located in London, but from their heart and mind they are still based in Pakistan. They still watch Pakistani news channels all the time, even though their wives told them off, but they don't give up. They still eat parathas in the mornings, and it is this diaspora which is actively engaged overseas, which is contributing significantly towards the intellectual development in Pakistan and economic sustainability in Pakistan. It is only natural for them to be engaged in a dialogue and to discuss issues which are affecting Pakistan today. As a lawyer, we all know that the purpose of justice is to provide protection from people and laws who seek to supersede Constitution. Constitution has provided a judicial role to judges and judiciary to interpret law as they find it. But there are judges who seek to re-litigate matters from the bench. There are judges who feel entitled to trespass into the authority of Parliament. This initiative is called judicial activism, which has been called in question in Western media. But for countries like Pakistan, judicial activism can provide a balancing factor itself. Pakistan does not have the concept of judicial restraint in action as such. In order to get rid of this confusion, I asked one of the prominent judges in Pakistan to define what is judicial activism. And he said, if you're a judge and you get up early in the morning and actively pursue your judicial duties, you are judicially active. Then I asked another lawyer in Pakistan, is there any judicial activism in Pakistan? And he said, you cannot define judicial activism, therefore it doesn't exist. It's a fanciful term created by those conservative lawyers who do not understand the substance and the complexities of the decisions. Then I rephrased my question and changed it and asked another legal author in Pakistan. And he gave me a very sensible answer. He said, whenever there is unfairness in the system and it permeates in the system, then the judges will exercise their judicial power to get rid of all the illegalities created by the legislature and executives. If there is judicial activism in Pakistan, it is a blessing. Whether there is any judicial activism, whether it is right or wrong in Pakistan, these are the topical issues we will be discussing here in our debate tonight. We have a wonderful constitution given by our late Zulfikar Shahid Bhutto. And our Chief Justice Iftikhar Muhammad Chaudhry provided a leading role in gaining independence for the judiciary. But can this judiciary play a significant and active role in shaping the future of Pakistan? And how this judicial activism, if it exists in Pakistan, can affect the political process in Pakistan? Can ends justify the means? Is it right to be judicially active? These are all the questions which we will be considering tonight, and no other person can give us better answer than our chief guest, Mr. Farooq Naek, who has successfully pursued his career as a lawyer in Pakistan. He has served as chairman of the Senate for 3 years and then reappointed as Minister of Law and Justice in April 2012. He has seen the democratic and political process going through and how the role of judiciary can encourage or help this. So I will be requesting our chief guest to come on the dais and share our views with us. Thank you.
Bismillah ar-Rahman ar-Rahim. His Excellency High Commissioner Wajid Shamsul Hasan Sahab, Honorable Barristers, Solicitors, Lawyers, distinguished guests, ladies and gentlemen, Assalamu alaikum, and a very good evening. I'm delighted to be here this evening among barristers, solicitors, lawyers, and representatives of Pakistani community based in UK and talk about judicial activism and democracy. But let me start by saying we Pakistanis in Pakistan are proud to have such a forward-looking and productive over 1 million strong diaspora in United Kingdom, contributing 20% to the national economy through foreign remittances. Our diaspora around the world, especially in UK, is Pakistan's most valuable asset. They have stood by the country through thick and thin and came up to the expectations and aspirations in most difficult, challenging, and stressful times. It has been a source of great strength to Pakistan. You, I must say, really and sincerely serve as the true ambassadors of Pakistan. You represent the true image of Pakistan, and the people and government of Pakistan looks toward you for support and resilience. It is heartening to note that today Pakistani origin businesses in United Kingdom contribute almost £33 billion into British GDP. They also help in maintaining a high volume of business and trade between the two countries, with annual bilateral trade between Pakistan and UK now crossing over £1 billion. The active participation of men and women of Pakistani origin in the realm of politics also is certainly very encouraging, and I feel proud to know that the presence of 7 MPs in the House of Commons and 4 members in the House of Lords. Your political participation is perhaps one of the most for the mainstreaming of Pakistani community in various spheres of life. I'm sure more and more Pakistanis will join in politics and play a lead role in the uplift of the community through motivating them to acquire higher education and joining diversified professions, thus making positive contribution to the society. Ladies and gentlemen, the topic of today, judicial activism and democracy, is such that any dissertation on the topic might be one of the most difficult and ticklish job. The essay almost tantamounts to walking on a tightrope. Both the concepts of judicial activism and democracy are volatile in nature and can never be conclusively circumscribed. A man like me, who is a lawyer, a parliamentarian, and a politician, honestly feel that the personal experience of every individual is always a fractional experience and can never display a holistic approach to human, social, economic, or political thought. It is said that there is nothing new under the sun, and all evolutionary and revolutionary processes in the world have been recurrent since time immemorial. Political science is a social science and not a physical one. Even physical sciences are dynamic, much less of social science. Ladies and gentlemen, democracy owes its origin to the word demos, which means common people of an ancient Greek state. Democracy is defined in Black's Law Dictionary, government by the people, either directly or through representatives. Government conventionally is entrenched in trichotomy of powers, that is, legislature, executive, and judiciary. The known function of judiciary has always been to interpret laws. Judicial activism has been defined as a philosophy of judicial decision-making, whereby judges allow their personal views about public policy, among other factors, to guide their decisions, with the suggestion that adherents to this philosophy tend to find constitutional violations and are willing to ignore precedents, its antonym being judicial restraint, which has been defined as a philosophy of judicial decision-making whereby judges avoid indulging their personal beliefs about public good and instead try merely to interpret law as legislated and according to precedents. The well-known saying about democracy need not be gainsaid, that democracy is a government by the people, of the people, and for the people, and that you can befool some people for all time. You can befool all the people for some time, but you cannot befool all people for all the time. Practical system in every democratic setup depends upon adult suffrage, political parties, and general elections. Governments so elected are accountable to the people who keep on judging it in respect of deeds and misdeeds during their tenure. Undue barriers in the working of the elected government representatives may choke implementation of their manifestos and in turn affect people's judgment of their performance. Fledgling democracies, ladies and gentlemen, cannot be equated with grown-up democracies. Every student of history, especially all of you sitting over here, are fully aware that judges of Supreme Court of United States had been exercising a lot of pressure on then governments, and tides changed when some presidents became gradually assertive. The history of separation of powers, read with the theory of checks and balances, is successfully pervading the constitutional evolution of the United States of America. United Kingdom is the mother of all democracies. Lord Canning and Lord Mansfield became protagonists of judicial activism. I may quote from a biography of Lord Canning by Edmund Hewitt that, and I quote, "Throughout the history of English legal system, there have existed two grand strands of judicial approach. There have been those judges who have taken the view that without usurping the functions of Parliament, a judge has the duty to interpret the law as far as he can in a way which accords with social and personal justice, which upholds, rather destroy, civil liberties of the individuals. There is another kind of judge who sees his task as maintaining the authority of the state, interpreting acts of Parliament narrowly, supporting the words of law in preference to the justice of the case, and affirming that it is for Parliament to change the law that turns out to be unjust or absurd, and not for judges to achieve that result through statutory interpretations. Now, ladies and gentlemen, coming from generality to particularity, superior courts in Pakistan countenance the breaches of constitutions sufficiently with restraint up to a considerable time. The first milestone in the process of judicial activism was laid down in the case of Al Jihad Trust, reported case against the Federation in PLT 1996 Supreme Court, in which it was ruled that consultation means meaningful consultation. This is with regard to the appointment of the judges of the superior courts. Thereafter, judicial activism went on in an ascending order in cases such as Sindh High Court Bar Association, Mubashir Hassan versus Federation of Pakistan, and suo motu cases, especially fixing the prices of sugar, rental power projects, and so on. Same is almost the trend in the neighboring country, India. Ladies and gentlemen, we should never be oblivious of the fact that bona fide comments or criticism, subjective or objective appraisal, can never be ruled out. It has been opened in respect of judicial restraint that justices should not embark upon issues which are not before them or yet to arise, that judges should not stamp their wisdom on issues in which they are not specialized, that they should not interfere into affairs where they do not have the full picture of events before them, that the judges should refrain to dilate an issue decree regarding a situation to which a different perception is possible by the persons who are directly linked or associated with the issue. Lord Denning was equally well loved and controversial, appreciated for his role as the people's judge and his support for the common man, and disliked by elements of the bar and the judiciary for uncertainty in the law created by his broad judgments. Haris Gazda has commented upon the repeated suo motus actions in the following words. There is a pattern: media-fueled populism, encroachment upon authority of the parliament and executive, helping political allies, and keeping mum where core interest of the military might be involved, unquote. In India, ladies and gentlemen, judicial activism is now being named as judicial excessivism. In the present political and judicial scenario, executive machinery is practically on tenterhook and unable to follow any coherent and consistent policy. Results of judicial activism are not so wholesome. Constitutional and judicial and jurisdictional backlog of cases is virtually at a standstill for a number of years in the Supreme Court. The bars have gone rampant. Conditions in the lower court have become appalling, and adhocism is prevailing all around. Unless the legislature, executive, and judiciary commit themselves to refrain from any transgression or encroachment upon inter se, the ship of the country can hardly sail on even keel. I am sure that all arms of the government in Pakistan will be conscious enough to adhere to the concept of trichotomy of powers in the larger interest of our homeland. Ladies and gentlemen, history records its verdict when incumbents of public offices and affectees or beneficiaries have vacated the stage. So every effort should be made to analyze any proposition in a most impersonal and objective manner. Islamic Republic of Pakistan has a written and a federal type of constitution. It should, as per parliamentarian and judicial norms, presume to be a rigid constitution. Preamble of the constitution, as also annexed to the same effect, read with Article 2A of the Constitution, lay down stark realities. It is manifestly laid down in Clause 3 of the preamble or of the annex that, wherein the state shall exercise its powers and authority through chosen representatives of the people. In another clause of the preamble and of the annex, it is laid down that, wherein the independence of judiciary shall be fully secured. Thus, mandate of the Constitution is manifestly clear that the government shall be run by the chosen representatives of the people. Thwarting any policy of chosen representatives would amount to usurpation of powers and infringement of the Constitution. Chapter 7 of the Constitution regarding the judicature nowhere describes the word suo motu. The express power of the superior courts given in the Constitution cannot be relegated to lackluster functioning at the expense of non-specified and hypothetical jurisdiction. Even some of the judges of the Superior Court now have themselves entertained apprehensions that there must be some check on the suo motu powers. It is paramount need of the hour that superior courts may have reprisal of the issue in all perspectives regarding the constituents of a viable democratic setup. As per Quranic injunction, ulal amr, that is, a person in authority is to be followed. Superior courts are expected to diagnose as to who are ulal amr, that is, the parliamentarians, the executive heads, or the judges, or a happy blend of all. Notwithstanding the nobility of objective, it is not for the judges to run the government. Despite widening sphere of influence, judiciary must not overwhelm itself and must not embroil itself in micromanaging the affairs of the executive or the legislature. Judiciary cannot endeavor to cause a reformation of society, as it is not its role. If it does so, it would inevitably lead and enter the minefields of doctrines such as law of necessity. Thus, judiciary needs to recognize its own role and strike a balance and equilibrium. Ladies and gentlemen, in the end, I thank His Excellency High Commissioner Wajid Shamsul Hassan, Barrister Farhan, for arranging this meeting and inviting me. I am also thankful to all of you for coming here and gracing the occasion and listening me with patience. Thank you. Pakistan, Pindabad.